So good morning, everyone. It's another pleasure to have everybody together again to have this wonderful event. Yesterday we have two great panels on discussions that were very interesting, certainly for me. And people are still coming to the event. And this is part of the dynamic of a virtual event. Is something that is a learning curve for our institution. IBDiC and ICLA, thank you all for your participation yesterday. I have to do some thanking in this opening. Some of them is for our sponsors and our supporters. Barros Pimentel Advogados, again, thank you. Oregon Act, Giamundo Neto Advogados, Toledo Marchetti Advogados, and Matos Filho Advogados. Thank you guys for the support. As for the supporters, we have the support of AACE, CIARB, CEBAR, Ibradim, Curso Prático de Arbitragem, and Infra Women. I have the most pleasure to have these other two panels today. One of the panels I'll be participating as one of the panelists, which is the next one. And I would like to very much give the word and the floor to my good friend and fellow of crime, Victor Madeira, and to say that it's an honor to be in a panel with him and with Aisha, Elina, Dong Feng. Victor, the floor is yours.
Thank you, Leo. Hello, everyone. I'm very happy and honored to be part of this event once again and to moderate this panel with colleagues and friends to discuss some relevant issues that we are dealing in these challenging times. I think before we start our panel, I just would like to explain to the audience, especially to the ones that are still not familiar with IBDiC, the Brazilian Institute of Construction Law, that we are a non-profit organization created to foster academic and technical discussions related to the construction market by means of several projects, such as, for example, this conference, the IBDiC library that is going to be will start this year. Also, the newsletter, the monthly webinars, and all of this are done by people that are directors, the regional directors, which I'd like to really thank these guys for really spending the time and effort to spread and develop the construction law in Brazil. I know that it's very hard to find time to spend on these projects, but without you, we would not succeed and to have this great event that we are having right now. For those who are not members of IBDiC, I really encourage you to join us and by visiting our website ibdic.org.br and this we really need your support and will be great to have more members and more discussions about the construction law. I would like also to thank our sponsors and supporters of the 2020 IBDiC ICLA International Conference, and a special thanks to Infra Women. That is one of our supporters that has been doing an amazing job promoting and encouraging the presence of women in the infrastructure sector. With that said, I would like to start by some initial remarks. As an active construction lawyer and and vice president of the Institute. I think that one of the duties, my duties, is to really promote some discussions about practical solutions for problems we are facing and our sector is facing. And right now, I think, as everybody knows, this pandemic is really affecting everyone, and especially in our market. So with that in mind, I proposed it to the rest of my colleagues of IBDiC that we had a more pragmatic discussion about with experts about the force majeure clause, which has a really important impact in the COVID discussion. As most of you know, the construction contracts, the analysis of one party may be excused from the performance of their obligations, should consider the force majeure clause for sure. And going back to the origin of the term force majeure, it's a French word, and that means a superior and irresistible force. In common and civil law, this commonly refers to unavoidable, like a catastrophes and some major events that were unforeseeable and that affect the contract performance. In general, the force majeure excuses a party for the performance of the contractual obligations, and usually a typical force majeure clause defines what are the events that fall under the concept of force majeure and the ones that should not be considered. Also specifies the standards, the requirements of notices and duties to mitigation, and also the consequence of force majeure, such as, for example, the suspension or even the termination of the agreement. However, some construction contracts used all over the world doesn't treat force majeure clauses the same way. And the idea of this panel is really to discuss this different treatment of standard forms, or even the ones that we use here in Brazil, which are not usually standard forms. So how the contracts are dealing with force majeure, and what are the issues that should be pointed out, especially to the construction market, about the importance of this clause and the consequence of not having specific provisions in the contract. In order to start our panel, I would like to present the speakers of today. I'm honored to be in this event, in this panel, first of all, with Aisha Nadar. She's a well-recognized arbitrator, mediator, adjudicator, dispute board member. She's based in Sweden. She's listed on the FIDIC President's list and holds a BS degree in electronic engineering, an MBA, and also LLM in international commercial dispute resolution. I also would like to welcome Elina Merimisakia. I'm sorry, Elina, if I spell wrong your last name. She's partner of Wagman and Sia, lawyers and engineers. She's a distinguished Russian construction lawyer and arbitrator, and she's based in Santiago, Chile. I also would like to welcome, and I don't need really to introduce you, Leo, but Leonardo Toledo, which is our president of the Brazilian Institute of Construction Law, is a partner of Toledo Marchetti Advogados, a professor of construction law at master's program of FGV, Direito, and a good friend of mine. And also, I would like to welcome Zhao Dongfeng, who is a senior partner of Beijing Shang law firm. He's a construction lawyer, an arbitrator, and a board member of ICLA, and also an executive director of the International Construction Law Program of Peking University. Thank you all. And I would like to start our panel by asking some questions. First of all, I'd like to ask to Aisha. Good morning, Aisha. Aisha, the first question I would like to ask you is related to FIDIC contracts. I know that you're a specialist and have a great experience on FIDIC. So I'd like to know from you related to this standard form. So how these forms deals with the force majeure events, especially related to what are the events that qualify as force majeure under the contract, what are the reliefs that the parties are entitled to under the clause, what the affected party need to do to preserve its rights in this event, and also how the FIDIC contracts deal with the duty to mitigate, and finally, how the FIDIC contracts deal with the costs caused by an event of force majeure. I know there are a lot of questions, Aisha, in a short time, but I know that your expertise will be great to hear from you.
Thank you for that very fulsome question. First of all, I'd like to say it's a privilege and a pleasure to have been invited to share in this esteemed panel. It's a great honor for me to be with you. I think I was just saying to Leonardo, one of the last things I did in the real world was to join a panel with Leonardo in Sao Paulo last February, which seems to be a lifetime away. But so I'll get on to the question. I think one of the things that you said in your introductory remarks is the typical force majeure clause. It sets out what force majeure is and then tells the procedure and how to deal with it and what relief is available. And I would say FIDIC is, and I'm going to limit my commentary to the FIDIC 1999 suite for just a moment, just to let the audience be on the same page with us. FIDIC is the acronym for the International Federation of Consulting Engineers. And since 1957, we've been publishing standard contracts that are pretty much used around the world. They are also used or mandated in certain multilateral development bank standard bidding documents. So they're part of the Inter-America Development Bank, which brings them to South America and Latin America. They're part of the African Development Bank, World Bank. So since 57, we've published quite a number of contracts, and only the 99 suite for major works uses the term force majeure. So that's, and if you look at the Red Book, Yellow Book, and Silver Book, in the 99 suite, Red Book being for construction only, the Yellow Book being design build, and the Silver Book being EPC, they handle force majeure in a similar in the same fashion. And you'll find force majeure in clause 19 of those three books. And 19.1 defines force majeure. So it defines it as an exceptional event or circumstance which is beyond a party's control, could not be reasonably provided against before entering into the contract, which having arisen, such party could not reasonably have avoided or overcome, and which is not substantially attributable to the other party. So that's the general definition of force majeure. Now, FIDIC, like many other contracts, enumerates a non-exhaustive list of what can be considered force majeure. So it goes on to say it can include war and hostilities, riots, munitions, and the last of those, so when we find in 19.1 subclause 5, we'll see natural catastrophes such as earthquake, hurricane, typhoon, or volcanic activity. Although it does not talk about pandemics or epidemics per se. FIDIC enumerates in a non-exhaustive list. So if it meets those 5, it's an exceptional event or circumstance with the 4, and it meets those 4 criteria that I talked about, then it can generally qualify. And I think we can all agree that COVID is beyond either party's control, was not reasonably could not have been reasonably provided for pre-contract, and having arisen cannot be avoided or overcome in a reasonable fashion by the party. So that sets out what can be considered force majeure. The clause goes on to say that there is a duty to notify once you become aware of force majeure. So, and that the requirement is for either party that finds it's in a situation that involves force majeure to give a notice to the other party within 15 days of becoming aware. And upon that notice, then the party that gave the notice will be excused from performance of the obligations for as long as the period of force majeure continues. It's important to note that the notice itself shall specify the obligations for which the performance is prevented. So it's very specific. It's what is the case of force majeure and what are you prevented from executing? There is a duty to mitigate the effects and the delays caused by the force majeure. The relief that you're excused from performance, but the relief that is available is generally time only. On very specific, narrow cases, FIDIC does provide for relief of time and money, but those very narrow cases involve war, rebellion, strife, riot, commotion that take place in the country where the works are being executed. So on average, if we're talking purely about this pandemic, COVID, it would fall under the criteria of force majeure. Parties would have to notify that a force majeure event has taken place, and it's going and specify which obligations they're going to be prevented from executing, and then to seek relief to ask for an extension or to seek that relief of extension of time, then they're going to have to follow the standard FIDIC claims provisions. And I think we many of us on the call know that FIDIC has a very prescriptive claims procedure. So if you have a situation of force majeure, you must give a notice that force majeure exists. Then to be granted the relief available, you must then follow the claims provisions as a contractor that are outlined in clause 20.1 of the 1999, which requires a separate notice that you intend to claim under 19.1 or clause 19 within 28 days of becoming aware of the event or circumstance that can qualify as force majeure, and then giving those a fully detailed claim within 42 days and then allowing the engineer to proceed under 3.5 to either facilitate agreement between the parties at what the impact should be, or to, if unable to reach an agreement between the parties, then to make a fair determination in accordance with the contract on that. So the entitlement is there. A separate notice under 19.2 that force majeure exists, and then the claims notice, the notification of claims, and that process has to continue alongside of that. And the duty to mitigate is a clear obligation under 19.3. I think I've answered all your questions. So please let me know where I might have
No,
missed.
that's excellent. Thank you, Aisha, for sharing your experience and your knowledge. It's great to have you here. The next question I'd like to do is to Leonardo. Just changing a little bit the scenario from existence of a standard form to another reality, which is the one that we live here in Brazil, which is one of the main characteristics of our market, which is the very incipient use of standard drafts. So in Brazil, as you all know, each company likes to use their own drafts without using drafts that were standard drafts that were tested. And in that scenario, I'd like to ask Leonardo, according to his relevant experience as a construction lawyer, which is focused on drafting and negotiating construction contracts here in Brazil, how the lack of this standard forms, the use of the standard forms affects the contracts in relation to the force majeure clause. So my question is, if there are contracts here in Brazil, according to your experience, Leonardo, that have just very basic provisions related to force majeure or inexistent provisions of force majeure, and also, in your opinion, what's the practical consequence of the lack of such provisions, especially in a situation as the one that we are living right now with the COVID pandemic?
Vitor, thanks a lot for your question. It's a very important question because it shows a little bit of the nature of the Brazilian market. It's so good to be again with everybody. And Aisha, we've been in this panel in another era ago. And in the other panel, if you recall, I was talking about something which was the clash of common law and civil law systems in terms of limitation of liability clauses. In this case, I cannot say that there is a clash, but there is a kind of a mixed salad that sometimes you put a little bit of anything. This is what happens in our system, because of course, when we receive standard forms or international practices, we have to adapt and also check our system to see to what extent it can be adapted. If you look, well, I've been negotiating and drafting contracts myself here in Brazil for a while, and I could say that there are some stages. In the beginning, what we see is that we have a definition of force majeure in our civil code, but it's a very simple definition. We have a civil code that is 2002, but it basically repeats the same definition of the civil code of 1916, which means it's a very simple definition that basically says that you cannot be enforced of your obligations for something that you cannot avoid. Kind of that simplicity, of course, we can discuss, because the legal doctrine in Brazil improved the idea of force majeure. So these are discussions in contractual law and private law and public law that is very much in presence. But that discussion doesn't take in place the construction scenario, which is something, is a different beast, to say a word. So the first stage of contracts here in Brazil were more simple clauses, where you would think they would basically refer to the definition of the civil code. And in this situation, there was also a influence by the public contracts. If you look at, because the major contracts in infrastructure in Brazil until not so long ago were always public contracts or contracts that had some relation with public contracts. So today, if you look at the legislation of public contracts in Brazil, even now, force majeure is one of the definitions that would allow you to adjust the contracting price and in the date of completion, and but with a lot of simplicity. A lot of simplicity. With that coming, what happened is the parties needed to negotiate every time something different would happen, and everything could fall into the definition of force majeure. That was the reality in the beginning. With let's say the internalization of Brazilian market after 1990, the 90s and first decade of the 2000, and we started to be in touch with all the international practice. IBDiC, for example, has been a very important influence in our countries. But what happened is that Brazilian people sometimes are very creative. We know that. So I would say that we have Frankenstein clauses. This is the second stage. We started to have Frankenstein clauses where the party that is drafting the contract first would take only what is interesting for them, then put in a sort of mix it. But there is still a doubt about one single point, which does force majeure allows you to relieve in financial or in only completion time, or also financial adjustments. This is something that even today is a discussion that we still have to have. It's important because this situation showed to us that our clauses were not bulletproof. I think I'll be discussing this later, but which is not the question that is made, but that is the discussion that maybe has to be revisited, because the actual situation showed some lessons here. But so the Frankenstein clauses gives us a more challenging situation where we have to go in a case by case, see what was the definition of the clauses. But in several situations, important aspects of, for example, a very structured clause like IBDiC clause were left behind. For example, you didn't have a time to notice about the event. There was sometimes a lot of copy and pasting, and things like earthquake, that Brazil never had one. And you would see clauses with this kind of examples that maybe we should adapt to our reality, and we didn't take the time or the courage to do that. But I would say that now, if you go to at least more professional companies that are more aware of international standards, our standards have become very similar to international standards of contract, which again, I think that there might be some discussions in these international standards, at least after this experience. But Victor, as answering the core of your question, the lack of definition of several procedures would make the parties have to agree and to negotiate. That was what happened, and of course that changes a little bit of the forces in the negotiation, because if you, as in IBDiC contract, you have a very structured procedure, the negotiation is very much defined what you have to do, what is the room for negotiation. In Brazil, everything was a room for negotiation. That was the difference. Thanks.
Thank you, Leo, for answering. Yeah, I totally agree with you. And force majeure clauses used to be like the midnight clauses, such as the dispute resolution ones that are left to the end of the negotiation, and nobody was, especially in Brazil, because we don't have very so many catastrophes like you have in other countries. So people were not so into really negotiate and put a very sophisticated clause. But I think things are changing, and I think I agree with you with this, especially with this scenario of pandemic. People are watching and taking more seriously this clause, and really trying to understand with specialists like you how to draft better clauses and to protect themselves in cases such as the one that we are leaving. Thank you, Mel. I will move forward to Elina right now. Thank you, Elina, once again to have you here. And I know that you have a very relevant experience as a construction lawyer here in Latin America, not only in Chile, but in other countries. So based on your experience, could you give us an overview of the main problems that are being facing by the parties in our region in connection with the force majeure clauses in this situation that we are living with the COVID, and how these problems are being addressed? I know there is a very broad question, but please just give us an overview of it based on your experience. Thank you.
Thank you. Well, first of all, I would like to thank you, Victor, IBDiC and ICLA, part of this outstanding event. It is a true privilege. And in response to your question, Victor, the main problem in your clauses is that those clauses are not suited to be applied to the current COVID-19 pandemic. Usually, force impossibility of performance, the party successfully invoking force majeure may suspend for the duration of the impediment, provided that the other party may also suspend its counter-performance. In is affected by a total lockdown, shutdown of the borders, and similar restrictive measures, the contractor faces the impossibility to perform. This would be a clear case of force majeure. However, the real question is, what happens when the contractor is allowed to resume the works? First, the workers will have to be divided into shifts in order to reduce social contact. Their body temperature has to be measured at the entry. In case of a COVID suspicion, all close contacts of a certain worker will be sent into quarantine. So the works will be delayed, but the contractor will continue working. Is this a case of force majeure? Second, additional PPE and sanitizers will have to be purchased. New cages will have to be built, where the personnel will get more social distancing. Due to the social distancing requirements, transport will increase, as well as the cost thereof. If the contractor continues, is it a case of force majeure? Can contractor ask for compensation of all those additional costs? Based on the force majeure provision, it certainly cannot. And because majeure provisions come too short to cover contractors' actual and future expenditures, many contractors have refrained from invoking force majeure, as it might reduce their chances to recover additional costs. And an interesting trend that we have seen, at least in Chile, is that in some cases, owners rely on to justify their non-performance in cases, for example, when they have to provide transport of the contractor's workforce, improve design, or just when they are willing to give an extension of time but have no intention to accept additional costs. Under Chilean law, parties' bargain is to be executed by its letter. Pacta sunt servanda continues the most fundamental principle of Chilean practice. Imprevisível, or the unpredictability theory, has a very limited recognition in the civil code and has been applied only exceptionally, mainly by arbitrators acting ex equo bono, and in long-term supply contracts. There is no legal regulation on frustration or hardship. And it's find contractual waivers of the right to invoke imprevisível or hardship. The question emerges whether the parties really have waived their possibility of relying on hardship, or whether such an agreement does not cover COVID-19. It could be argued that the global world pandemic was not a situation that could have been foreseen by the parties, and therefore it's not covered by the waiver. And as we heard at yesterday's panels, the responses from different jurisdictions vary significantly, and the responses from different contract parties have been different as well. I have seen owners suspending contracts temporarily at their own discretion, owners giving contractors a couple of weeks of EOT just to adjust to the new sanitary conditions, owners insisting on COVID being force majeure event, contractors resisting force majeure notion, contractors relying on contractual change in law provisions, and contractors relying on. I like to quote an epistemological principle. I know what I know, I don't know what I don't know, and I don't know that I don't know what I don't know. COVID-19 reality is this last scenario. With the virology, nobody knew, he did not know how to live under and to under pandemic. Those the scope of force majeure definition, they should acknowledge that they are facing a situation that they had not addressed contracts, and that the legal system probably don't in an adequate way either. Therefore, they should different negotiate prices, enter into in-depth analysis of their insurance provisions, and draft new COVID-related provisions. Owners should do that as well to avoid contractors going in being abandoned. The parties should resort to all the available non-outstanding disputes. They certainly should avoid court systems that will be overflooded with cases, and save arbitration for exceptional situations. This would be my answer.
Excellent, Elina. Thank you for sharing your experience, and I totally agree that we should avoid courts. And the next panel will deal a little bit about the views of judges and arbitrators about that. But I believe that yesterday we learned that collaboration is a way, and I think is the most appropriate way to deal with this crazy situation we are living. Thank you. Moving forward, I would like to ask Zhao Dongfang a first question. Zhao, I'm very eager to really hear you about China, and because China today is the main global player in construction and infrastructure projects, with approximately 21% of the global share. So most of the construction and infrastructure projects are happening in China. And China also was the first country to be affected by the COVID. So I would like to know how did the pandemic affect the projects, especially the ones related to the One Belt, One Road initiative, and also how the existing construction contracts deal with this situation. If you could please share your experience, would be great. Thank you.
No, you're in mute, Zhao.
Can you hear me now? Can you hear me?
We can hear you, Zhao.
Okay. That means I need to. Yeah. Thank you very much, Leonardo and Victor. I'm very glad to share my experience of China with you guys and audiences. And first, from the medical or scientific perspective, I have to say that China is the first country reporting COVID-19 to the world. And the whole world began to know COVID-19 from China's report. So it does not mean that China was the first country to be affected by the COVID-19. Okay, then regarding the effect of COVID-19 for the construction projects in China, within China, and construction projects along the One Belt, One Road, I think there are two stages. There are two stages. The first stage is from the end of January to early April this year. And the second stage is from the middle April till now and forward. The effect in the two stages is quite different for construction projects within China and outside China. Okay, I want to explain to tell you what happened during the first stage. During the first stage, because people know nothing about the virus, and the government know nothing about it, and so it caused chaos and panic nationwide. People worry about to be infected by the COVID-19, by the virus. So as you know, in order to control the spread of the virus, the COVID-19, Chinese government shut down the whole city of Wuhan with population of more than 11 million residents. And then almost all transportation throughout the whole country, among cities, towns, and even rural areas, villages, almost closed. So, which means almost the whole country suddenly stopped movement and froze. And the government has to extend the official holiday of Spring Festival. So, and this background, almost all construction projects in China suspended. People stay at home. Machine equipment stopped running, and materials could not be delivered to the job site. So it is obviously the construction projects within China was severely affected during the first stage. And then during the first stage, for the projects in along One Belt, One Road initiative, the countries, which are undertaken by the Chinese companies, were also affected very much, because Chinese staff and the labor by Chinese government to stay at home, required to stay at home, you should stay at home and do not go outside. So Chinese people were joking at that time that in the history, it is the first time for people to stay at home. Sleeping means a great contribution to the country. So it's the first time in the history. Just sleeping at home, that means you make great contribution to the health and to the whole benefit of the population. Yeah? So they cannot travel to the project site. They cannot travel to the other country because many countries have closed their border and refused Chinese people to enter into their country. The international transportation closed, the visa can they get the visa, but they still refuse to go to the country. So that means almost all the construction projects along the One Belt, One Road have been affected. There are many disputes. I have dealt with from the early January until now, almost every day, I'm dealing with the effect by the COVID-19. Even today, one of my clients, a very big client, approached me to advise their Mongolia project, and the government, the owner wants to terminate because of the delay of the project. So it's very serious. And so in the second stage, this is just now is the first stage. In the second stage, I mean from early April until now, things goes better. People have understood to some extent COVID-19 and accumulated experience how to avoid infection by the virus, such as wearing mask, washing hands, keep distance for social activities, not gathering in the closed space. So in the second stage, I can tell you, I also divided into two types of projects. One is within China, the other is the construction projects along the One Belt, One Road. For construction projects within China, China begin gradually recover from the adverse impact of COVID-19. And construction projects have been gradually resumed. But of course, it still has subject to careful protection, careful restriction. For example, all the staffs, the laborers, they need to, in order to avoid infections, they need to have enough sufficient PPE, personal protection equipment, and when they enter into the job site, they have a checkpoint, and everybody needs to go through to scan their face, because to test their body temperature. If your body temperature is more than 37, like this, you will be carefully supervised, or even send you to the hospital to check whether you have been infected or not. But anyway, because the Chinese government take a very severe measures against the virus, so the virus spread almost stopped in China. So of course, the severe measures was criticized by international communities. It said that you do not respect human being. This is the reality. But anyway, for most of the Chinese companies and people, they think protecting life is the most important. And for individual to sacrifice some individual's freedom or something, they think they can't accept. So that's the reality in China. This is for the construction projects within China. For the construction projects along the One Belt, One Road, or other sides of China, recently, from early April until now, more and more countries have allowed the Chinese staff, Chinese labor to enter into their countries to resume work, but still subject to a very strict restriction. For example, before you travel to for the Mongolia or even Brazil, I don't know Brazil's regulation. For Mongolia, for example, Chinese staff or labor needs to get a nuclear acid test negative in the past 7 days to show that you have no problem, you are negative. And then when you arrive at the country, you have to have a 14 days or 21 days quarantine period in order to show that you're healthy. You do not bring the COVID-19. So this is the second stage. But currently, the adverse effect caused during the first stage, now has been shown. In the past 2 weeks, I have dealing with 2 projects, very big projects. One is in Mongolia, the other is in Kazakhstan, and another also in Argentina. In Argentina, the owners intends to terminate the contract because of the delay. They think that your Chinese guys, you cannot work as scheduled, so we terminate. But even terminate, some owners do not think that COVID-19 is a force majeure. They don't think it's force majeure. So there are disputes. So that's what I want to tell you, what Chinese construction companies faced and have been facing.
Thank you, Zhao. It was very interesting to hear about how things are happening in China. And I think it's very similar to most of the rest of the world. So moving forward, I would like to ask a few more questions to the other panelists.
Okay.
So first, I would like to ask Aisha a very tough question to you, Aisha. So I want to know your opinion. In your opinion, if the FIDIC force majeure clauses are being effective regarding the impacts of COVID-19, and if FIDIC is discussing a potential change in these clauses, and due to this new reality that we are living, and also if, in your opinion, there is any improvement that could be done in these clauses in order to address this issue.
Yeah, but you're right. You're asking me a tough question. So
the first one was hard.
Yeah, and yes, so they get tougher. We're going uphill here. So let me see if I can maybe do this some justice. Are they being effective? I think listening to Elina earlier about, it depends on the employer's view. Some employers are cognizant that of the fact that there's mutually assured survival. If you focus today with this pandemic on the black letter and the 4 corners of your contract without taking into consideration the overall nature of what's happening, be it economically, the social impact, and the impact to the industry and national economies, I don't think that if I would say, if I can reframe the question, is the FIDIC contract being effective to find the best possible solution or the most effective solution in the current circumstances for the parties? I think if you take clause 19 in isolation, the answer would have to be more than likely not. Because as Elina was talking about, having the PPE, having the social distancing, so it's not only a matter of an impact of time, it is a matter of impact of finances to the contractors. And can they sustain that impact? Maybe they could if the pandemic, if a vaccine was created or generated and tested when Zhao was talking about in phase 1. But if we're going to go, if the Spanish flu is going to be, or the 1918 flu is going to be any indication of what we're facing, of this 18 months plus cycle, then of course it can't be effective in isolation, just a force majeure clause. So, and I think FIDIC recognizes that. If we yesterday, I think I heard David Brown using the term the beast of FIDIC, or the English or common law beast. It is true that the FIDIC forms come from a common law. They were born in the common law world. They are a derivative of the first forms in the Institute of Civil Engineers. So they didn't have this force majeure principle. The principle of impossibility is enshrined in clause 19. I didn't talk about that. It's the last provision. And so if it is impossible to carry out the contract, you can terminate. But is termination the solution of choice? More than likely not. So I think, but what FIDIC does offer is the dispute resolution or dispute management provisions that go alongside of the clause 19. And I think if we look at the way FIDIC approaches risk and allocation of that risk and the impacts of that risk eventuating, there is a focus on mitigating risk. Each party has that duty to mitigate the risk, mitigate the impact of risk that eventuates, and then to find solutions with the help of an outside third party, this person that we call engineer with the capital E, and if that fails, the dispute adjudication board. So if we look at, if there's the COVID-19 situation, the impact, be it force majeure or not, it could have been, there could be changes in law and perspective. I think Elina mentioned, and FIDIC addresses that in 13.7, if there's a change in law mandating a closure and the like. So there's time and money there. If reduced supply of goods, in 8.4, there's a possibility of an extension of time. So we can't look at force majeure in isolation. We have to look at it in the total FIDIC system in parallel with the dispute management, such that it really promotes collaboration and conversation between the parties with the engineer's support and with the dispute adjudication board's support, and also making real-time decisions to facilitate that. So, I mean, I think I haven't given you maybe a yes or no clear answer, yes, it's perfect, or no, it's bad. I think it must be taken as a whole. And now when we talk about a 100-year event, is FIDIC or any other contract designed to withstand, or should it be then tailored for this 100-year event? I think we can learn from it. We can learn from the possibilities of how we can enhance the procedure and the allocation, but I don't think we should modify it structurally in a way to address this event and move away from, I mean, if we look at the civil law perspective, on average, there is a compensation or an extension of time, but there's no money for the event, or a payment or financial compensation for the impacts of force majeure. Does that need to be changed? I think if you're a contractor, if you look at any of the international contracting federations, they would say, yes, it needs to be changed. If you are an employer and you say, I allocated my public purse, I don't have any more, I can't do anything else, they would probably say no. The answer is probably somewhere in the middle, and it's got to be negotiated on a case-by-case basis. I've seen around the world situations where employers that have multiple construction contracts ongoing at the specific time, they've kind of sat down and created a position as an employer's position for all their contracts. What are they going to compensate for? What are they not going to compensate for? I think this is a time where we have to say, the four corners of the contract are not the only thing that we need to look at. And we need to be cognizant that this is about mutually assured survival, not only mutually assured success. So does that answer? And so we're not,
No, perfect.
not changing.
Yes, I should know. You're always brilliant with your answers. So I totally agree with you. There's no bulletproof clause that could protect us at this time. and we should really find solutions. And I think FIDIC is great on that, especially to give these tools, as you said, dispute boards and other kinds of dispute resolution methods that could try to put the parties in an agreement on how to resolve this issue. Moving forward, I would like to ask Leonardo another question. Leo, about the new construction contracts that are being executed during this COVID pandemic, what are your recommendations? And we want this for free, Leo, related to how the force majeure clauses should be drafted, and also the lessons learned related to such event to the new contracts that are being executed.
I was enjoying very much Aisha's answer because it relates to this question too. And I think it was interesting. Of course, this terrible event brings us some look at our solutions. It was clear, as Elina also mentioned, that none of the clauses of any places were, let's say, totally effective to deal with something that nobody would think of believing that would happen, but it happened. And especially in Brazil, as Victor said, we are grateful to God that we don't have many wars, we don't have many situations in earthquakes or nature problems. Our problems in the different fashion, we have problems. But there is one lesson learned that I would like actually to even talk to Aisha about it, because what I hear when people are thinking of what is the lesson to learn is people are very much connected with risk allocation. Oh, should we think of risk allocation a different way? Maybe price adjustment in that situation, maybe. What happened in the situations we represented, for example, contractors and represented employers? The employers that stood up for their contract in the beginning, saying that, no, I don't have to adjust anything in terms of financial relief, they ended up negotiating. So they stood for a while in an illusion that they wouldn't have to negotiate, because they were protected by risk allocation. But at some point they realized that the problem wouldn't go away for a while. You could do that for a month, but you couldn't do that for a year. Possibly when you do that, you are giving your counterparty the termination clause, which is a clause that almost every contract has. So at some point they realized that this is not a solution. And also the contracts. In the side of the contractors, of course, for those who can, because Brazilian legislation is a bit more open than common law systems. It was mentioned several times here that we also have a situation for rebalancing the contract in situations of extraordinary situation. But the fact is that force majeure in these conditions of rebalancing of the contract for extraordinary situations kind of clash a little bit of when is one and when is another. But the fact is, the lesson learned is that any time that we propose a crisis committee, the situation flourished. The situation the situation for negotiation improved. So what is the lesson learned here for FIDIC, for everybody? what is the best part for FIDIC is that they have, for example, a recommendation for DAB, which is a external tool for governance. External tool for governance. It makes the party has to deal with decision making. What I'm trying to say here is that when you put a solution for situation that you cannot prevent or you cannot mitigate by one party only, the solution is to shift the mentality of risk allocation to a mentality of internal governance. Of course, it dialogues a lot with the discussion of collaboration. Yesterday, I couldn't help myself because it's something that I always want to talk about, but it's becoming more and more clear that solutions for risk that nobody can mitigate, nobody can allocate. It goes for situations in which the contract, for example, I could think of a contract saying the parties are obliged to form a crisis committee with one member for each other anytime they feel something that I'm not sure exactly how. This is something that has to be discussed. But I believe that shifting the idea for negotiation and governance, not only risk allocation. You don't need to change risk allocation. You can keep it. But the fact is that risk allocation doesn't solve this problem. This is a bigger problem. So what happened in new contracts, whenever I can and negotiation is possible, I try to find this kind of joint governance for situations of extreme dealing. That would be my question, Victor. I'm not sure if it's...
No, perfect, Bao. I totally agree with you. And I think this is the way. And it's good that you and Aisha have the courage to really put your views on that. Most of the people try to not really get into a position when we are dealing with this subject. So it's great to hear you. Moving forward, I would like to ask Elina another question, and now shifting a little bit from FIDIC to the ICC, the International Chamber of Commerce clause. I know that on March 2020, they issue a long and a short form of force majeure clause. So I'd like to understand, Elina, I know that you're really involved with ICC and you know very well these clauses. So how, I'd like to understand how this form, these clauses deal with the force majeure, the reliefs that the clause grants to the parties, and the notice of requires something similar to what I asked Aisha, but in relation to the ICC clause. And also, if you, in your opinion, this form addresses the issue of the pandemic in an effective way. Thank you.
Thank you, Victor. Well, ICC had worked on the revised version of this clause between 2017 and 2019, and it was published at the onset of the pandemic, so it has attracted a lot of attention. I would like to highlight three aspects thereof: the definition, the consequences, and the duty to mitigate. First, definition. ICC itself recognizes that the definition of force majeure provides a lower threshold for invoking the clause than impossibility of performance. So it would address my earlier concern. It is enough that the event prevents or impedes a party from performing one or more of its contractual obligations, in addition to other usual requirements, being the event beyond parties' control, etc. So if we apply this concept to a construction project, it is not required for the works to have been stopped completely due to a lockdown. If, for example, due to the new sanitary conditions, contractor is not achieving the milestones, is not completing the construction schedule, it is with obligations, those COVID-19 could be deemed a force majeure event. This would help. The clause provides a number of so-called presumptions, which only requires the party to prove that the impediment could not reasonably have been avoided or overcome. Otherwise, the force majeure nature of the event is presumed. Among those presumed force majeure are epidemic and act of authority, whether lawful or unlawful, compliance with any law or governmental order. With this, COVID governmental measures seem to be covered by the definition, as the contractor is not a wizard and cannot overcome them. Well, it does not use the term pandemic, but it's easy to construe epidemic that affects the entire world, so it's gonna be covered most probably. And with regard to the consequences, there are the usual consequences of a force majeure. The party will be relieved from its duty to perform its obligations under the contract and from any liability and damages. Once again, contractor gets time, but no cost. And as we were discussing earlier, it could be sustainable over a short period of time, but not over 18 months. And there is also a possibility of contract termination by either party if the impediment exceeds 120 days. The right to terminate the contract applies when the impediment has the effect of substantially depriving the contracting parties of what they reasonably entitled to expect under the contract. The language is somehow similar to the one used in the UN Convention on International Sales of Goods. Under that convention, substantial deprivation means that the asset won't serve at all, similar to a wedding dress made with black fabric. It is hard to imagine that this will be complied with in construction projects, as the sheer 120 days delay in a project delivery won't deprive owner of the benefits of the project. We have seen projects delayed for far longer than that. And third, the duty to mitigate, which is very interesting. The obligation is to undertake all reasonable measures to limit the effects of the event. And the issue has an impact. For example, could you require the contractor to mitigate COVID-caused delays and the impact to zero? Should the contractor withdraw all manpower to avoid the contagion as mitigation? Should the contractor buy the vaccine once it becomes available? These discussions will be necessary related to cost recovery. ICLA does not provide any sanction in case the duty to mitigate is not complied with. So it will be left for arbitral tribunal and courts to decide whether the impacts contractor's right to recover at least time. Well, in general terms, in my opinion, it is a good force majeure clause. Well drafted, clear, has a long term, has a short term, could be included into a contract by a simple mention of the clause. It is not necessary to copy the clause entirely. The problem is, once again, that it's a force majeure solution, which, as we were talking before, does necessarily cover all the contingencies the construction projects are experiencing today. At the same time, ICC includes a hardship provision, which applies when the continued performance of contractual duties has become excessively onerous due to an event beyond reasonable control, which could not expected to have taken into account at the time of the conclusion of the contract. And the consequence of is the duty to contractual terms. So we are back to what Leo was talking before. The parties to opportunity to create an internal administrative structure, or to rely on the structures that are provided by DIC, SHIM, for example. And in the alternative, the parties can to opt between the ability of terminating the contract or resorting to judge, to arbitrator for the adaptation of the contract. Certainly, the adaptation of the contract has all the advantages both parties require. The contractor will continue performance, it will get compensated, and the owner will obtain the project at the end. In case of the contract terminations, the party will obligations, and the owner will be confronted with the choice of either abandoning the project, continuing it with another contractor. Well, owner usually can terminate the contract based on discretional decision. It's in most of the contracts we've already seen, so it's not clear whether it's such a necessary solution. But in order to enter into a new it will have to adjust commercial terms to the current situation, current COVID-impacted situation. So in commercial terms, the more expensive project. Therefore, I guess the adjustment of contractual terms is obviously a better solution, because a termination of the contract would lead to almost the same result, and with additional time that the owner will have to incur it. That's
excellent, Elina. I totally agree. I think termination is the last resort, and is only in the current case is the only necessary if the parties stop talking and trying to find a collaborative way to live the situation. I would like to have a last question to Zhao Dongfeng. Zhao, what were the lessons learned in relation to the Chinese experience with the pandemic? And based on such lessons learned, what are your recommendations regarding the new contracts that are being executed?
You're in mute, Zhao. You're mute. I do that all the time.
Hi, Leonardo. I think when Victor asked me the first question, because the signal is not very good, I did not answer his second question. It means, how did the existing construction contracts deal with the consequences of such event in China? Do you think it's necessary for me to see again? To see, or just jump into the question? Can you hear me?
Yes, I asked it, the second question was related to the lessons learned. You should also, if you want to answer, to complete your first question. But right now I'm asking about what were the lessons learned in relation to the Chinese experience, and also what are your recommendations for new contracts in view of your experience?
Okay, Victor. I think for the standard constructing contracts, I'll just give you a very brief to the audience, or a very brief introduction. Okay. And for the, I would like to give you some the existing construct contracts in China, how they deal with the COVID-19. Currently, because there are two types of contracts. One is the contracts for the domestic products, and within China, that means within China, Chinese government issued a standard construct contract, and we call a standard construct contract or model construct contracts. In these contracts, there is a clause we call force majeure. Okay, force majeure clause. Now in China, COVID-19 is regarded as a force majeure, especially from the starting, from the early January is regarded as force majeure. So I share with you what Chinese standard contract do. I quote some parts of the clauses for your reference. It said that if force majeure adversely affects the performance of the contractor's obligations, resulting in delay, then the completion date should be extended, and any additional cost occurred shall be shared reasonably between the employer and the contractor. And further, the salary paid to staff and laborers during the suspension period shall be paid by the employer. And in the event that the completion date is delayed by force majeure, the employer instructs to accelerate the additional costs in relation to the acceleration shall be borne by the employer. So from this standard construction contract, you can see to a large extent it benefits the contractor. So these force majeure clauses causes great chaos in China among employer and contractors, because according to this standard construction contract, these standard clauses, that means the employer almost will bear most of the costs, the losses. So later I will tell you what Chinese government and court to do. And then for another type of project is just you mentioned it for the overseas projects carried out by the Chinese construction company. The Chinese contractor prefer use the FIDIC because our colleagues, our experts, panelists, they have discussed the FIDICs. So I do not want to see more, but actually, this use FIDIC causes great dispute, because from the contractor's perspective, if they see COVID-19 is force majeure event, that means principally the contractor can get EOT, extension time, but almost no cost. So the contractor try to find other clauses. Just now I remember I listened to Aisa mentioned that the Chinese the contractors try to use the FIDIC 1990 clause 13.7 clauses. It means changes in the legislation. That because according to that, because the government issued a lot of regulation, the decrees or orders to dealing with to combat against the COVID-19. So they think this changes the law to some extent, because according to this clause, the contractor entitled to EOT as well as cost. So now for construction projects overseas Chinese, but undertaken by the Chinese contractors. This is they prefer use the FIDIC, but the FIDIC causes disputes. Okay, this is the standard construction contract I want to share with you, used by the Chinese contractors. And then what lessons? What lessons the Chinese experience we learned dealing with impacts of pandemic in the construction projects? I would like to brief some measures adopted by Chinese court, government authorities, how to deal with COVID-19. Okay, first, the Chinese court acted very quickly to issue 3 guidelines. That means the court need to follow the guidelines to hearing the cases in relation with the COVID-19. I'll give you an example. First, in the guideline number 1, the Chinese Supreme Court issued the guideline number 1 in February this year. I share with the Article 2. The Article 2 is said that when hearing the case involving COVID-19, the court shall, in accordance with the law, accurately apply force majeure rules. That means in China, it is almost very clear COVID-19 is regarded as a force event, and strictly control applicable conditions. And Article 3 said that in respect to cases of contract dispute directly resulting from COVID-19 or measures adopted against COVID-19, the court, when applying laws, shall comprehensively take due regard of the effect caused by COVID-19 to different areas, different trade, and different cases, accurately consider causation and causative potency between failure to fulfill contract and COVID-19 or measures adopted against COVID-19, and proceed in accordance with the following rules. I share with you rules. The rule 1, in the event that COVID-19 or measures adopted against COVID-19 leads to failure of part or full contract, taking into the extent effect taking into effect of the COVID-19 and measures adopted in IT, then the court can step in to determine whether to discharge part or whole contract. This is rule 1. This is rule 2. If COVID-19 or measures adopted against COVID-19 leads to difficulty for parties to fulfill the contract, emphasize difficulty, not impossible, parties in concern can renegotiate. With regard to those contracts which can be continued to performance, the court should try to mediate and actively guide the parties to continue performance. That means the court said that I need to negotiate, mediate. If you do not, provide in the contract that mediation, I will try to mediate. And then go on. As regards party request to terminate the contract on the basis of performance difficulty, the court will not support such a request. If continued performance is obviously unfair to one party, such party request to change performance period, performance method, or contract price, etc., the court shall determine whether to support such request or not, taking due regard of actual situations of the case. If the contract has been changed as per the law, the party will still request to discharge their part or liability. The court will not support such request. If the purpose of the contract cannot realize due to COVID-19 or measures adopted against COVID-19, the court shall support the request. And the third rule, I think it's very important. In the event that the contract parties receive subsidy, tax reduction from the government, or the financial assistance from the other entities, debt reduction or exception, the court will take account of these factors when determining whether the contract can continue or not. I understand the Chinese government, because in China is the main economic body is state-owned enterprises. So it's a community, party. So that means the government step in to do a lot of things. And then this is the first guideline number 1. And then the guideline number 2 is specifically dealing with the construction. I share with you, said that number 2 said if COVID-19 or measures adopted against COVID-19 causes the contractor unable to achieve the completion as provided in the contract, and the owner still requests the contractor liable for such failure, the court will not support such a request. If the contractor requests extend the completion date, the court shall, taking account of the extended effect from COVID-19 or measures adopted against COVID-19 to the performed contract, give appropriate support. In the event that the COVID-19 or measures adopted against COVID-19 causes the cost of staff and labor, materials, etc. largely increased, or the contractor incurred loss, which will result in obvious unfairness to the contractor. Then the contractor requests to adjust the contract price. The court will take due regard of the action in the case, and in accordance with the principles of fairness, make the adjustment accordingly. So this is court practices. They worked very quickly to deal with the COVID-19. Besides the court, the Chinese government also acted very quickly and actively published a lot of regulations and decrees. For example, the Ministry of Housing and Urban Rural Development China and its local subsidiaries, they issued guidelines about how the state-owned enterprises to dealing with the COVID-19. For example, they said that they request all the parties to share the adverse impact on the basis of fairness and the reasonableness. That's the principle. That means if your company, construction company, you're under the direction, under the governing by the Ministry of Housing and Urban Rural Development of China, that means you have to follow. This is the regulation. This is the order. Another is tax authority. Tax authority quickly issued the tax measures. For example, reduce the VAT rate of medium small size enterprises from 30% to 1%. And also security department, social security department, they also act very quickly. They reduce the rate of social security paid by the employer to the employee. Such as, for instance, in Hubei province, I know, maybe you know Hubei. The Wuhan city is the capital of Hubei province, and the Hubei province government issued that the employer does not need to pay the social security for the employees for 5 months, and also Chinese government gives subsidy to the company, to the contractor, said that if you do not fire your employees, we give you subsidy. That means not like USA, United States. The United States give money to the individual, but in China mainly give the company and request the company to retain the position, not to fire their employees. But this is a different way, maybe in China and USA. USA, they pay the money directly to the individuals, but China is different. So I think from Chinese down, I summarize some lessons or experience. First is all the entities, the government and judicial, they should act quickly, cooperatively, and with solidarity. So this is the first lesson. The second is that adopt a package of measures to maintain the fairness commercially between stakeholders in construction industry. From what I brief, you can see that facing such sudden attack, Chinese judicial authority, government authority quickly promulgated a lot of guidelines, policies, and regulations to maintain the balance of economy, commercial fairness among stakeholders affected by COVID-19. So this way, trying to avoid a lot of bankruptcy or insolvency and a large number of unemployment. I think this is very important.
I'm sorry to interrupt you, but we are running out of time. I'm sorry, but I was very interested to hear from you all your thoughts and also to understand what's going on in China and all these measures taken by the government. Very interesting. I will just open like 5 minutes to final remarks if any of you want to do it. I will open first to Aisha. Aisha, would you like to do some final remarks?
I wanted to make a note that I've been answering some of the questions on chat, so I hope that was okay, that they were addressed. But I think taking a page from what Zhao said and what Elina said and what Leonardo said, that nothing without collaboration is going to work in these extraordinary times. I mean, whether you have an impact to certain provisions, your entire project, whether you have legislative changes or not, we're all, I think humanity is in this together, not only a particular construction project or the contractor or an employer, it is nations and the global community at large that's in this together. And if we don't cooperate, some of us may survive, but many of us won't. And so I really think it's a time to kind of step back and look at the broader picture and focus on mutually assured success and or survival, because it's a time to share and collaborate and negotiate and think of the society and not only of a particular project. But with that being said, that's the kumbaya focus. But I think we still have contracts, we still have rights and obligations. And, you know, I would say document, document, document. Make sure your position is known, make sure your position is supportable, and make sure your position is defensible and protected. But with that strength, then focus on negotiation and focus on collaboration and finding possible solutions.
Perfect, Aisha. Thank you very much. It was great to hear you. Leo, do you want to do some final remarks?
Just one thing. It's also clear that one message that I wanted to deliver in my last question is, and it's clear for in everybody's speech here, is that there is a shift that is needed. Not only risk allocation, but governance, sorts of governance, sorts of tools to improve negotiation. One thing that we have to have in mind is that it's not a matter of, as Sasha said, a kumbaya only. There are tools available for us to improve negotiation, to improve governance. So what I expect from decision makers and people that are structuring contracts is that be aware of these tools and try to understand how they apply. DAB, DRB, they are one tool of governance. Of course, they are external, but there are other tools, simple tools that are internal. So try to look at your situation to this perspective, not only thinking, oh, now I have a broad obligation to negotiation, but let's think of structuring contracts to put parties in a situation where negotiation is more likely. and the exchange of information is more likely, because in situation of stress, unfortunately, the first response is a mutual distrust. But at the end of the time, it has to come to bond and find common solutions. That's the final word. Thanks, Peter.
Thank you, Leo. Elina, do you want to do some final remarks?
Very brief. I would like Aisha's wise words, the same. I would like to issue a call to the companies, owners, and to escape the hands. Litigation lawyers, wonderful gremium, but it's very important for when they have the saying, and they should stay with it, negotiate, mediate, and think prospectively of future projects.
Thank you, Elina. It was great also to hear you. And Zhao, do you want to do some final remarks?
Right, yes, Victor. I think I used the last 5 minutes to finish your last question about my recommendations. I think this is my general remark. I think for COVID-19 issue, I propose, according to my experience, I think it's necessary to put a special clause directly dealing with the COVID-19 and measures adopted by government or public authority dealing with the COVID-19. You know the reason? Because currently, if the contractor or the employer still say that COVID-19 is a force majeure, no, somebody will say, no, it's not force majeure because you have no COVID-19 happens. But COVID-19 happens. They know the phenomenon, this natural phenomenon. But where to happen, when to happen, and when happen, what measures the government and the social authority will adopt? Nobody knows. Nobody can foreseeable. But in order to avoid this disagreement or dispute about whether COVID-19 or measures adopted is a force majeure, I think just to put it a special clause dealing with COVID-19 based on the reasonableness and loss sharing spirit to solve this problem. I think that's my general remark, and I think that's a way to dealing in the medium period before the special medicine can cure the COVID-19 infected patients quickly. Otherwise, there will much more disputes. This is my general remark.
Excellent. That was great to hear you, and thank you, everyone. Thanks to the audience. And
thank you very much, Victor.
It was great to have you here. So we are now having a quick interval, and then we'll come back with the last panel. Thank you.
Thank you very much, Victor.
Thank you, Aisa.
Thank you, everybody. It's been a pleasure. Bye-bye.
Thank you, everybody.
Yes. To be with you.
Thank you all.
G.
Looking forward to see you next time.
Thank you, everyone. Okay, this first panel it's ended. Lovely to discuss that again, and it could be for at least more, couple of hours, but it's what we have for today. I would like to stress a little bit more about one project that we are, a social project that IBDiC is supporting, which is Casa José Couto. Again, we put on this event in a free subscription. Of course, I know that it's important to touch on our community and to make a difference. So Casa José Couto has been making a difference in some social environments that need assistance in Brazil. So I'll ask very much everyone that can collaborate with Casa José Couto that you received an email, even for those who are outside of Brazil, you can have this help by a PayPal account. And of course, nobody's obliged to do that, but we very much would like to recommend and give us our support to Casa José Couto. So now we would like to show a little bit of the project of Casa José Couto, and we'll show you guys a video. And after that, we will have the last panel of this event. Thanks a lot.